Next speaker is Alexis Hughes, and you said you are speaking for a group. Welcome to the podium.
My name is Alexis Hughes. I'm speaking on behalf of a group called You Heard Her. We are a group that advocates for transparency, parents, students, teachers in the district that do not feel comfortable coming out and speaking. Can you please restart my time?
Yes, please go ahead.
Alrighty. John Adams once said, facts are a stubborn thing. I'll add one more thought. The rule of law means absolutely nothing if facts, statutes, and court precedent are only applied when they produce the outcome we want. Tonight, that's exactly what I'd like to discuss. For months, we have heard we have to follow the law, court precedent, and state statutes. Let's concede, for the sake of tonight, that those have been truly the reasons for inaction. If that's true, then let's be consistent. Because we don't get to selectively decide which laws, precedents, and statutes deserve attention. I'm here tonight to talk about another law, a law that doesn't apply to parents, students, or teachers. It applies to your own superintendent. If Grimm mattered then North Carolina General Statute 115C 272, requiring a superintendent to reside in the county they serve, matters too. If legal compliance matters when parents ask you to protect our girls, then it matters when it concerns the highest paid employee in this district. There cannot be one standard for citizens standing at this podium and another for the man sitting beside you. Mr. Chairman, before this meeting concludes, I will be handing a formal letter requesting that this board investigate whether John Kopicki is in compliance with the North Carolina statutory residency requirements for superintendents, with public records supporting my concerns attached. This letter has also been provided to members of the State Board of Education, legislative leaders responsible for education oversight, and other officials who have an interest in ensuring compliance with North Carolina law. Mr. Kopicki, public records indicate you remain registered to vote in Pennsylvania and are not currently, nor have you ever been currently registered to vote in North Carolina. More importantly, that you routinely travel back home to Pennsylvania to vote in person as recently as the 2024 general election. 3 years after you began your employment here. Your vehicles remain registered in Pennsylvania, one parked in this very parking lot tonight. You still own a home in Pennsylvania. Your wife and your family all have full-time jobs and residences in Pennsylvania. If those public records do not tell the complete story, by all means, please enlighten us. Transparency should never frighten a public servant. On June 5th, I submitted a FOIA request seeking Mr. Kopicki's employment contract and all extensions and amendments. I am still waiting over a month later for that. Why? This board has repeatedly told the community that transparency matters to them. So why is one of the most basic public records regarding the highest paid employee in this school district still being withheld? Every taxpayer in Cabarrus County has the right to ask some very legitimate questions. If Kopicki's legal domicile is Pennsylvania, as the public records attached to my letter appear to suggest, where is he filing his state income taxes? If Pennsylvania remains his legal domicile and home, how does that square with North Carolina's statutory residency requirement? Where is vehicle taxes, registration fees, and property taxes being paid? Where is the economic benefit of a taxpayer-funded six-figure salary ultimately ending up? Every dollar this board pays him comes from the taxpayers of this county. Those taxpayers deserve to know that the people leading this district are fully invested in the community they serve and its success, not simply employed by it while their permanent ties and economic interests remain invested in Pennsylvania. This board has both legal and moral obligation to act. This isn't political or personal, it's because accountability demands it. This moment is bigger than bathrooms, it's bigger than locker rooms, and it's bigger than one superintendent. It's about whether this board exercises independent oversight or simply accepts what it's told to do. You were elected to govern this district, not rubber stamp the administration. Public confidence is not built by caring more about the manner in which a citizen speaks versus the substance of his speech itself. Apply the same standard to your own administration that you've demanded from every parent, teacher, student, and citizen standing before you. The rule of law doesn't protect the powerful, it binds them. If the law, facts, statistics, and court precedent only matter when they produce the outcome you want, then they don't matter at all. The law either matters for everyone or no one. Tonight, this board is not merely being asked to investigate one superintendent. You are being asked to prove through action whether all those speeches about law, precedent, and statutory duty or actual principles you stand on are just excuses to not act. Because if you invoke the law only against the public but hesitate when it reaches your own administration, then you are not upholding the rule of law, you are protecting power. And what you do next will tell this entire county which one it is.
What? Okay, thank you, Ms. Hughes. Our next speaker is